bring in, Gene, our very special guest. His name is Alex Flynn. He's a criminal defense attorney there in Milwaukee, but very significant in this case.
And outside in Milwaukee also, our new friend Alex Flynn, as we said, well-known criminal defense civil attorney out there.
Let me turn to Alex now. Alex, hold off a minute going one side or the other in this particular case, but when you've got multiple defendants, if you're trying to defend one of them, how tough is that?
In this case, all these defendants are trying to stay allied in their defense. They're all kind of remaining embraced. They're really not condemning one or the other, but we don't know yet. We don't see the end yet. In the end, in the closing arguments, what one of the lawyers could say, Spangler's lawyer could say, for example, Bartlett's the bad guy, he did it, but I had nothing to do with it. I thought this was a cross-examination. As I was listening to this, I heard somebody say it's direct, and I said, what? This is a direct examination? Very, very interesting subtext might be going on here, because if he is a hostile witness, he can be treated as though he is on cross-examination. He can be deemed an adverse witness by the judge. The prosecution can ask for that, and then leading questions can be put to him. That apparently has not been done, but what we're seeing is a very skilled examination of him that looks like a direct, but it's really a cross.
Now that is a very common strategy. Explained.
Oh, I think that was done deliberately and intentionally. That was Ryan Packard yesterday, and he clearly was there assisting the defense. He had been called by the prosecution because they needed some of his evidence, and although he was a hostile witness, it didn't rise to the level of him being an adverse witness, that is, having the judge deem him adverse so that the prosecution could ask cross-examination questions, leading questions. But he clearly was there, and he clearly, in my mind, had prepared with the defense. And what he had done is at the right moment, at the conclusion, in a very poignant, symbolic moment, he said, "Now stand up, sir." And he stood ramrod straight, this handsome man with his blue uniform, the Milwaukee police uniform. And what he was doing is drawing from the goodwill accrued over the decades by most of the people on the Milwaukee Police Department of enjoying a degree of credibility by virtue of that uniform.
And the interesting thing here, Alex, is that we have people coming in with uniforms on, the trappings of authority, but you know, you're getting dramatically different testimony. I mean, this is not the kind of thing where you can argue, well, maybe he just didn't see what the other said.
I think the wearing of the uniform is a very powerful image that's being used by both sides here. Very interestingly, they are to disregard the fact that he has not taken the stand. That I think the jury instruction reads, the defendant has an absolute right not to testify, and you shall not use it in your deliberations. But there is going to be an expectation here that he will. But as pointed out earlier, it is usually a last-minute decision to see how it goes.